The American Bar Association Standing Committee on the Federal Judiciary has rated Mr. Higginson with a unanimous, well-qualified vote. I intend to vote for his nomination, and I thank the Chair and yield the floor.
Mr. President.
Senator from Louisiana.
Thank you, Mr. President. I understand we have about 4 minutes on our side, and I thank my colleague, Senator Grassley, for his kind words of support and strong words of support for the nomination that is before the Senate today. And I rise to support the confirmation of Stephen Higginson to the U.S. Court of Appeals for the Fifth Circuit. I was pleased, Mr. President, to recommend Mr. Higginson to President Obama to be considered for this nomination to this important post. And I'm pleased to be joined by my colleague from Louisiana that also supports this nomination and supports this confirmation. I'd like to take just a moment to share with some of my colleagues a few highlights of Mr. Higginson's background and resume. He has been well prepared for this position. He has resided in New Orleans with his wife Colette Crapol with their 3 children, Christopher, Katie, and Noel. But prior to that, he began with a degree from Harvard, graduating, as Senator Grassley said, summa cum laude. After graduating, he went on to earn a master's in philosophy, which is unusual but very welcomed in this field, from Cambridge University. He went, Mr. President, as a Harvard scholar. With degrees from 2 very prestigious institutions, he decided to pursue his J.D. from Yale Law School, where he graduated 3 years later. He earned the extraordinary distinction of being both editor-in-chief of the Yale Law Review and the winner of the Israel H. Perez Prize for the best written contribution to the Law Review. After graduating from yet another prestigious school, Yale Law School, he served as law clerk to the Honorable Patricia M. Wald of the U.S. Court of Appeals in the District of Columbia, and then he also served as law clerk to the Honorable Byron White of the U.S. Supreme Court. Clearly, his academic and professional accomplishments have prepared him to handle the legal complexities of federal appellate cases. But, Mr. President, all of these things, I think, can be put into context beautifully by comments from his judges that he will serve with should he be confirmed today by the Senate. Other justices on the court. Judge James Dennis of the Fifth Circuit describes him this way. He says, Stephen has all the qualities one needs to become a great judge and great colleague. He will be a great addition to our court, and I look forward to serving with him. Another Fifth Circuit judge just mentioned, Judge Edith Clement Brown, called Mr. Higginson, quote, the best criminal lawyer that has ever practiced before me in all of my 20 years serving on the federal bench. And finally, from the man he will succeed should he be confirmed, Judge Jack Weiner, who took senior status last year, he says, quote, I've long admired Steve Higginson's advocacy for the U.S. Attorney's Office here in the Eastern District, his scholarship as a law professor, his outstanding academic record at Harvard and Yale Law School, and his exemplary citizenship here in New Orleans. I'm distinctly honored to have Mr. Higginson succeed to my seat on this court, and confident he will discharge the duties of the U.S. Circuit Court judge fairly, conscientiously, and honorably. So, Mr. President, I ask with my strongest recommendation for my colleagues in the United States Senate to vote with me in approving this nominee today. I thank you.
Senator from Louisiana.
And, Mr. President, I rise and I'm honored to join my colleague from Louisiana, Senator Landrieu, as well as others, Senator Leahy, Senator Grassley, in strongly supporting this nomination, a very, very strong nomination. First of all, Mr. President, let me say I'm very happy to work in a very close fashion with Senator Landrieu on all of the judicial nominations in Louisiana under President Obama. And I have to say that work and that cooperation has gone more smoothly with better results than I could ever have imagined. So I'm very, very pleased with that entire process. This nomination of Steve Higginson is perhaps the strongest, most shining example of that. Senator Landrieu and I worked very closely together. We were very focused on this important Fifth Circuit nomination. Quite frankly, we were both concerned about someone that the White House was looking closely at for the nomination. We both together expressed that concern, and then we both very much supported this nomination of Steve Higginson. Senator Landrieu, through a process she set up independently, suggested Steve Higginson as a nominee, and I very immediately and passionately and strongly chimed in. We did this because this is a highly qualified individual who will make nothing less than a great judge. As has been mentioned, Steve has a sterling record and many different facets of it. He's an associate law professor at Loyola Law School, where he's gotten great admiration from both his fellow professors, his colleagues, and his students. And he served for about 2 decades as a federal prosecutor in various offices of the U.S. Attorney, mostly the U.S. Attorney for the Eastern District of Louisiana since 1993. During this time in Louisiana, Steve has handled multiple investigations and criminal trials, first at the trial level, then at the appellate level. And he supervised both criminal and civil appeals. In this role, he's authored over 100 federal appellate briefs, and he's reviewed more than 300 appellate briefs authored by others. And of course, that's very, very directly relevant to this job on the U.S. Fifth Circuit. Now, Mr. President, this work and the entire work of this U.S. Attorney's Office has been extremely important for us citizens in Louisiana in at least 2 respects. First of all, this U.S. Attorney's Office, led by the current U.S. Attorney Jim Letton, a career prosecutor initially appointed by President Bush and kept on by President Obama. Jim Letton in this entire office has made enormously important strides in cleaning up political corruption in Louisiana with several landmark prosecutions. And Steve Higginson has been an important part of many of those landmark prosecutions. Secondly, Mr. President, in the immediate aftermath of Hurricane Katrina, this U.S. Attorney's Office, headed by Jim Letton, aided very much by Steve Higginson, was extremely instrumental in helping local prosecutors and local law enforcement recover from the blows of Hurricane Katrina, get back on their feet, and move forward with important criminal prosecutions. So, Mr. President, a U.S. Attorney's Office is always important to a community, but I point out these 2 ways in which Steve Higginson's work under U.S. Attorney Jim Letton has been particularly significant for us in the greater New Orleans area. Steve came very well prepared for all of this work. As was mentioned, he has an exemplary academic career, including editor-in-chief of the Yale Law Journal, no small feat. And he also served as law clerk to Supreme Court Justice Byron White. His work in the U.S. Attorney's Office has also been recognized in myriad ways. He's gotten many, many awards. I'll just mention 1 or 2. For instance, the Excellence in Law Enforcement Award from the New Orleans Metropolitan Crime Commission, again focusing on that very important anti-corruption work and post-Katrina work. And at Loyola Law School, as I mentioned before, Steve has been recognized and lauded both by his colleagues on the faculty, his peers, and by his students. In fact, from his students, he's won Loyola's Professor of the Year Award 3 times in just a few years. So Steve really will bring a wealth of public experience to the federal bench, and is exceptionally qualified to serve there. Mr. President, I believe that the Constitution is very clear that judges must interpret the law and not legislate from the bench. And I think our most solemn responsibility in terms of confirming federal judges is to make sure we confirm judges who respect that rule of law and who live by that rule of judicial restraint. And I'm confident that Steve Higginson will be just such a judge as well. So, Mr. President, again, I'm very pleased to join my colleague from Louisiana, Senator Landrieu, and to join so many others in a very bipartisan way, including the chair of the committee, Senator Leahy, the ranking member, Senator Grassley, in strongly endorsing and supporting this nomination of Steve Higginson to join the Fifth Circuit Court of Appeals. Thank you, Mr. President. I yield back my time.
The clerk will call the roll.
Mr. Akaka.
Put in the record as if in morning business.
If the senator could please move the vitiation of quorum call.
I ask that request.
Without objection.
Okay, thank you. Mr. President, on Friday, a week ago, Secretary of HHS made a very important announcement regarding one specific provision of the Patient Protection and Affordable Care Act. Secretary Sebelius announced that the administration would no longer be implementing the Community Living Assistance Services and Support Act. The acronym CLASS applies to that part of that health care bill. She said, and I quote, "When it became clear that the most basic benefit plans wouldn't work, we looked at other possibilities. Recognizing the enormous need in this country for better long-term care insurance options, we cast as wide a net as possible in searching for a model that could succeed. But as a report our department is releasing today shows, we have not identified a way to make CLASS work at this time," end of quote. Mr. President, this is not an I told you so speech, although it certainly could be. It isn't as though folks weren't raising significant concerns about the CLASS Act a long time before it ever passed. 2 years ago, during the debate, member after member of the Senate came to the floor to argue that the CLASS Act was destined to fail. Senator Thune led the fight to raise awareness about the fiscal disaster that the CLASS Act has now turned out to be. The Democratic chairman of the Budget Committee called it, quote unquote, a Ponzi scheme. The Democrat chairman of the Finance Committee stated on the floor that he was, quote, no friend of the CLASS Act, end of quote. When the Senate took a vote on the CLASS Act, 51 senators, including 12 Democrats, voted to strip it from the legislation. The majority didn't rule that day because an agreement required 60 votes to strip it out. Mr. President, I think a special recognition goes to former Senator Judd Gregg of New Hampshire. As ranking member of the Budget Committee when he was still in the Senate and a senior member of the Health Committee, he was deeply concerned about the ultimate cost of the CLASS Act on future generations. He led an amendment to require the CLASS Act be actuarially sound. He did so not because he wanted to improve the CLASS Act, but because he wanted to make clear how the CLASS Act could not work from a fiscal standpoint. His amendment showed that once implemented, the Class Act would take in revenues in early years and then begin to lose revenues in the out years, ultimately either failing or requiring a massive bailout by taxpayers' money to salvage this program. In a strange twist of budget scoring rules, his amendment, once accepted, led the Congressional Budget Office to score the Class Act as producing savings on paper in the short term. The score made clear that the Class Act was doomed to failure. But as only happens here in Washington, a score showing the obvious failure of the Class Act then became an asset, particularly an asset because the Democratic leadership wanted to show that this bill was revenue neutral or even revenue positive. But it was used by the Democratic leadership not for what it provided beneficiaries, but what it did for the overall health care reform bill. With the Class Act and its imaginary savings in the bill, and it made the overall bill look like it actually saved money. Those savings, of course, were a gimmick. Everyone in Congress knew it, but some chose to ignore it, or worse still, celebrate it. The very first action on the floor for the Affordable Care Act was for the majority leader to ask unanimous consent to prevent amendments from spending the imaginary savings, and I emphasize imaginary savings, generated by the Class Act. It wasn't a motion to protect the Class Act itself, but a cynical motion to protect the previous savings and the political value that they had. Now, only in Washington, with overwhelming evidence on the table making clear a program would fail, would defense of the doomed Class Act become a virtue. The head actuary at CMF stated, quote, "There is a very serious risk that the problems of adverse selection would make the class program unsustainable," end of quote. The risks were known then, yet the Democrats in Congress plowed ahead anyway. Why, you may ask? Well, Megan McArdle noted in The Atlantic on Monday, the problems with the Class Act were known from day one, but no one would listen because it gave them good numbers to sell their program politically, end of quote. And it wasn't just political cover. The imaginary savings gave them protection against potential budget points of order. Would the Senate-passed bill have been subject to a budget point of order without the imaginary Class Act savings that were in the bill? That's a very legitimate question. The announcement by the Secretary of HHS provides an overdue vindication for Senator Gregg. His amendment made the announcement inevitable. Health and Human Services could not make a viable case for implementing the Class Act because Senator Gregg's amendment requiring the Class Act to be actuarial sustainable. Our next action is clear. Congress should repeal the Class Act. It was not in the House health care reform bill. A majority of the Senate voted to strip the Class Act from the Senate bill. It was passed under laughable false pretenses. The responsible action for Congress is to repeal it in the first relevant piece of legislation. Mr. President, I take a back seat to no one on issues associated with improving the lives of seniors or the lives of our disabled. As ranking member of the Aging Committee, I oversaw critical hearings into deeply and persistent problems in our nation's nursing homes. I was a principal author of the Medicare Part D prescription drug bill, which is currently providing our seniors and people with disability with affordable prescription medications. On the disability front, one of my proudest achievements is the enactment of legislation I sponsored along with the late Senator Ted Kennedy, the Family Opportunity Act, which extends Medicaid coverage to disabled children. In a large part, through my efforts, the Money Follows the Person Rebalancing Act and the options for states to implement a home and community-based services program were included in the Deficit Reduction Act of 2005. Along with Senator Kerry, I introduced the Empowered at Home Act, which, among other things, revised the income eligibility level for home and community-based services for the elderly and disabled individuals. So, Mr. President, that is what I said about the Class Act on December 4th, 2009. Quote, if I thought that the Class Act would add to this list of improvements to the lives of seniors or disabled that I have sponsored in the past, I would be first in line as a proud co-sponsor of the Class Act. But the Class Act does not strengthen the safety net for seniors and the disabled. The Class Act compounds the long-term entitlement spending problems that we already have by creating yet another new unsustainable entitlement program. The Class Act is just simply not viable in its current form. That's the end of quote that I made on December 4th, 2009, when that provision of the health care reform bill was up. But this is not an I told you so speech. No, Mr. President, I'm here because I'm offended by the way this administration and proponents of health care reform have used the disability community throughout the debate over the Class Act. Congress and the administration knew the Class Act would fail when it was being considered. The administration now somehow manages to treat this as a shocking discovery, and the fact that they're doing that is beyond me. But the way that the administration has tried to soften the blow for the disability community rubs me the wrong way, because in the Secretary's statement that I just referred to, the Class Act, the Secretary said this, quote, in fact, one of the main reasons we decided not to go ahead with Class at this point is that we know no one would be hurt more if Class started and failed than the people who had paid into it and were counting on it most. We can't let that happen, end of quote. Of course, they could have opposed the inclusion of the legislation and told the disability community the exact same thing back in 2009. Apparently, the administration is trying to tell the disability community that even though HHS can't implement the statute, they don't want to repeal it. We do not support repeal, said Nicholas Pappas, a White House spokesman. Quote, repealing the Class Act isn't necessary or productive. What we should be doing is working together to address the long-term care challenges we face in this country. Mr. President, and that's the end of quote. Mr. President, after putting the political value of the savings ahead of the doomed policy, the administration finally admitted the Class Act was a failure. They apologized to the disability community. They said they don't support repeal of the Class Act. After years of dodging reality, it's time for the President and the majority party to treat the disability community respectfully and honestly. If the President believes the Class Act can and should be saved, he should put revisions on the table, much as he's threatened to in the early 2010 and never managed to. Congress should weigh repeal of the Class Act against whatever revisions could be proposed to make it a legitimate program. We should do so with a full score, meaning from CBO, and in the context of our current fiscal climate, with all the cards on the table, not the stealthy way it was handled in 2009. We should have a healthy and open debate. The insipid strategy of passing something into law with a wink and a nod towards making it all better in the future is unacceptable and disrespectful to the disability community purported to be served by the legislation. Mr. President, our course is clear. For those of us who care about the disability policies, the days of ignoring reality must come to an end. We should repeal the Class Act and move on to other legislation that gets the job done in a fiscally responsible way. It's 5.
Clerk will call the roll.
yield back the time on this side.
Time is yielded back. All time has expired. The question is on the nomination. Is there a sufficient second? The yeas and nays have been requested. There appears to be a sufficient second. The clerk will call the roll.
Mr. Akaka, Mr. Alexander, Ms. Ayotte, Mr. Barrasso, Mr. Baucus, Mr. Begich, Mr. Bennett, Mr. Bingaman, Mr. Blumenthal.
Aye.
Mr. Blunt. Mr. Bozeman. Mrs. Boxer. Mr. Brown of Massachusetts. Mr. Brown of Ohio. Mr. Burr. Ms. Cantwell. Mr. Cardin. Mr. Carper. Mr. Casey. Mr. Chambliss. Mr. Coates. Mr. Coburn. Mr. Cochran. Ms. Collins. Mr. Conrad. Mr. Coons. Mr. Corker. Mr. Cornyn. Mr. Crapo. Mr. Dement. Mr. Durbin. Mr. Enzi. Mrs. Feinstein. Mr. Franken. Mrs. Gillibrand. Mr. Graham. Mr. Grassley. Mrs. Hagan. Mr. Harkin. Mr. Hatch. Mr. Heller. Mr. Hoven. Mrs. Hutchison. Mr. Inhofe. Mr. Inouye. Mr. Isaacson. Mr. Johans. Mr. Johnson of Wisconsin. Mr. Johnson of South Dakota. Mr. Kerry. Mr. Kirk. Ms. Klobuchar. Mr. Cole. Mr. Kyle. Ms. Landrieu. Mr. Lautenberg. Mr. Leahy. Mr. Lee. Mr. Levin. Mr. Lieberman. Mr. Lugar. Mr. Manchin. Mr. McCain. Mrs. McCaskill. Mr. McConnell. Mr. Menendez. Mr. Merkley. Ms. Mikulski. Mr. Moran. Ms. Murkowski. Mrs. Murray. Mr. Nelson of Nebraska. Mr. Nelson of Florida. Mr. Paul. Mr. Portman. Mr. Pryor. Mr. Reed of Rhode Island. Mr. Reed of Nevada. Mr. Risch, Mr. Roberts, Mr. Rockefeller, Mr. Rubio, Mr. Sanders, Mr. Schumer, Mr. Sessions, Mrs. Shaheen, Mr. Shelby, Ms. Snow, Ms. Stabenow, Mr. Tester, Mr. Thune, Mr. Toomey, Mr. Udall of Colorado, Mr. Udall of New Mexico, Mr. Vitter, Mr. Warner, Mr. Webb. Okay, gotcha. Mr. Whitehouse, Mr. Wicker, Mr. Wyden, Senators voting in the affirmative: Bingaman, Blumenthal, Boxer, Cantwell, Cardin, Cochran, Conrad, Crapo, Grassley, Harkin, Hatch, Heller, Inhofe, Inouye, Isaacson, Johans, Landrieu, Leahy, Shelby, Tester, Udall of New Mexico, Vitter, and Webb. No senator voted in the negative. Mr. Coburn, aye. Mr. Reed. Mr. Reed of Rhode Island, aye. Mr. Graham. Mr. Graham, aye. Mrs. Gillibrand. Mrs. Gillibrand, aye. Mr. Coons. Mr. Coons, aye. Mr. Carey. Mr. Carey, aye. Mr. Udall. Mr. Udall of Colorado, aye. Mr. Johnson. Mr. Johnson of South Dakota, aye. Mr. Brown. Mr. Brown of Massachusetts, aye. Mr. Carper. Mr. Carper, aye. Mr. Nelson. Mr. Nelson of Florida, aye. Mr. Sessions. Mr. Sessions, aye. Mr. Hoven. Mr. Hoven, aye. Mr. Akaka. Mr. Akaka, aye. It is. Mr. Manchin. Mr. Manchin, aye. Mr. Lugar. Mr. Lugar, aye. Mr. Wicker. Mr. Wicker, aye. Ms. Collins. Ms. Collins, aye. Mr. Casey. Mr. Casey, aye. Mr. Johnson. Mr. Johnson of Wisconsin, aye. Ms. Murkowski. Ms. Murkowski, aye. Mr. Toomey. Mr. Toomey, aye. Mr. Moran. Mr. Moran. Aye. Mr. Paul. Mr. Paul. Aye. Mr. Levin. Mr. Levin. Aye. Mr. Lee. Mr. Lee. Aye. Mrs. Shaheen. Mrs. Shaheen. Aye. Mr. Lieberman. Mr. Lieberman. Aye. Mr. Brown. Mr. Brown of Ohio. Aye. Cole. Mr. Cole. Aye. Mr. Sanders. Mr. Sanders. Aye. Mr. Chambliss. Mr. Chambliss. Aye. Mr. Nelson. Mr. Nelson of Nebraska. Aye. Mr. Enzi. Mr. Enzi. Aye. Mr. Wyden. Mr. Wyden. Aye. Mr. Merkley. Mr. Merkley. Aye. Ms. Snow. Ms. Snow. Aye. Mrs. Feinstein. Mrs. Feinstein. Aye. Mr. Menendez. Aye. Yes. Mr. Franken. Mr. Franken. Aye. Mr. Portman. Mr. Portman. Aye. Mr. Whitehouse. Mr. Whitehouse. Aye. Mr. Lautenberg. Mr. Lautenberg. Aye. Mrs. Hagan. Mrs. Hagan. Aye. Mr. Baucus. Mr. Baucus, aye.
Aye.
Mr. Bennett. Aye. Ms. Klobuchar. Ms. Klobuchar. Aye. Mr. Corker. Mr. Corker, aye. Mr. McConnell. Mr. McConnell, aye. Mr. Barrasso. Mr. Barrasso, aye. Mr. Rockefeller. Mr. Rockefeller, aye. Mr. Kirk. Mr. Kirk, aye. Mr. Kyle. Mr. Kyle, aye. Ms. Mikulski. Ms. Mikulski, aye. Mr. Alexander. Mr. Alexander, aye. Mr. Thune. Mr. Thune, aye. Mr. Cornyn. Mr. Cornyn, aye. Mr. Bozeman. Mr. Bozeman, aye. Mr. Pryor. Mr. Pryor, aye. Mrs. Murray, aye. Mr. Begich. Mr. Begich, aye. Ms. Stabenow. Ms. Stabenow, aye. Mr. Schumer. Mr. Schumer, aye. Mr. Reed. Mr. Reed of Nevada, aye. Mr. Durbin. Mr. Durbin, aye.
Are there any senators in the chamber wishing to vote or change their vote? If not, the nomination is 88 yeas, no nays, and the nomination is confirmed. Under the previous order, the motion to reconsider is considered made and laid upon the table, and the President will be immediately notified of the Senate's action.
Mr. President,
Majority Leader.
I ask unanimous consent that
Order in the chamber.
we now proceed to appear in morning business. Senators allowed to speak for up to 10 minutes each.
Without objection.
I understand Senator Moran is...
Senate will resume legislative session.
Mr. President.
Who do I get? Senator from Kansas.
Mr. President, thank you. 2 weeks ago, I spoke here on the Senate floor with some of my concerns about the pending legislation that have been talking about now a number of appropriation bills, including the committee report on agriculture. Last time we visited about this, I talked about the GIPSA rules. I want to focus on one more area of concern in this appropriation bill, and that is that the Department of Agriculture has proposed a rule to revise the nutrition requirements for the National School Lunch and Breakfast Program. In its current form, the rule contains some impractical nutrition standards and goals. I don't think there's any of us here in the Senate, and certainly every parent that I know we all want our children to have nutritious food, and we want them to have nutritious food at home and at school. And that's not the point here. It's not the question. What I would raise is, and I question whether the Department of Agriculture's rule is realistic for schools and for those who provide food to the schools, that they're able to comply with this new rule. For example, as written, the rule would exclude many nutritious vegetables in school meal programs. Appropriately, the Senate adopted an amendment offered by the Senator Collins from Maine, which I supported, that allows school nutritionists to continue to make their own recommendations based upon the most recent dietary guidelines for Americans, rather than they have to follow the mandates issued in this latest USDA rule. In my view, that's exactly where these decisions should be made, in schools around our country by nutritionists, not mandated here by our government in Washington, D.C. Furthermore, we must keep in mind the impact that this rule will have on school budgets and food suppliers. Unfunded mandates like this one will make it even harder for schools to provide healthy lunches for students. The Department of Agriculture estimates that the cost of compliance over a 5-year period will reach $6.8 billion. The federal reimbursement already does not cover the full cost of preparing a meal in many schools across our country. This new USDA rule will further drive up the cost of providing lunches, and school districts will have to make up the difference. This doesn't seem like a reasonable approach when many school districts are already struggling to make ends meet. Let me give you an example of what's in this rule. Once finalized, schools would be required to reduce sodium content of school breakfasts by up to 27% and school lunches up to 54%. There are a couple of problems with this requirement. There is no suitable replacement for sodium that can maintain the same function of flavor and texture. Also, reducing sodium is not just a function of limiting raw salt content. Many ingredients have salt in them, sodium, that occurs naturally. School food suppliers have been working for years to reduce the amount of sodium in their food products. However, they need additional time to come up with a solution that balances nutritional value with taste so that kids will eat the school lunch. This rule would also change how nutritional content is measured. Rather than measure nutrition based upon density, the Department of Agriculture rule proposes to measure nutritional content based upon volume. For example, tomato paste is nutritionally dense, but the Department of Agriculture says it must meet the same volume as a fresh tomato. That doesn't make much sense. Why would we take a metric to be the arbitrary volume requirement instead of just measuring the nutritional value? The bottom line is that kids can still get the right nutrients from food products if they are measured by nutritional content. A more sensible approach to making sure children have healthy options for breakfast and lunch would be to work together with scientists, nutritionists, and industry representatives toward a set of intermediate goals. Food costs, service operations, and student participation rates could then be more closely evaluated before moving on to the next goal. This would give school districts and food suppliers the chance to make changes on a more reasonable time frame. Our colleagues in the House included a provision in their version of this legislation that directed the Department of Agriculture to issue a new proposed rule that would not add unnecessary and costly regulations to the school lunch and breakfast program. Unfortunately, this language was not included in the Senate version of the bill, and in conference I will continue to work with my colleagues to make sure that the Department of Agriculture is not making it harder for schools to provide healthy lunches, but instead is working alongside local schools and their officials to develop better nutritional goals.
Clerk will call the roll.